Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope you are doing well. We are now back at it on day 6 on the Kouri Richins trial. We just heard from Dr. Erickson, and now we have some more lovely people coming up. So let's get right back into it and see who is the next person up for witness. I say next item up for bid, but it's not really item up for bid. It's the next witness.
The May 4th, 2023 interview. I think, I don't want to speak for him, defense had a chance to review it, but we'll still have an objection.
Ms. Lewis, please.
Yes. Your Honor, we still object on two grounds. One is still hearsay. There's not only just the statements of Mr. Crozier and Detective Davis and Detective, I think, maybe was the other one there?
It was Ben Carino.
That's okay.
I'm certain it was Ben Carino. You can think all you want. It was Ben Carino.
We have law enforcement side, and then we have the Mr. Crozier side.
Right, but then we also have law enforcement making statements to Mr. Crozier, statements from Nicole Cummings and Carmen Lauber. So there's those hearsay statements in there also. And the other thing is, it says that it can be admissible under 801D if when the person's subject to cross-examination. I know Mr. Crozier was subject to cross-examination, but he's no longer subject to cross-examination. It seems as if this video should have been introduced prior, because then we would have had the opportunity to show him portions of the video and cross-examine him on the video. That opportunity is now lost.
Why?
Well, he's been released from his subpoena. We don't know if he's been out talking about the case. I suppose.
Well, you could ask him about that, but he's not unavailable.
Well, that's correct. We could subpoena him and bring it back in. That's true.
And I just want to make sure I understand the procedural history here. Defense had the video, right?
Yes.
To the extent it had wanted to cross-examine him regarding the video when he was on the stand, you had the opportunity, and there may have been good reasons to not do it at the time.
Well, the main reason was he had no memory of it, so that made it difficult.
Well, that's exactly the condition that triggers 801D1A.
Well, 801D1A is if there is inconsistencies in it.
Or has forgotten.
Yeah, word for it. I don't have it in front of me.
I mean, I think that is the basis to have a discussion regarding admission of the video, his side of it, right? Under 801D1A is that he was testified numerous times under oath in open court that he couldn't remember the interview, even to the extent of saying that piece of transcript does not refresh my recollection.
Correct.
So I can instruct the jury to not consider anything other than Mr. Crozier's statements for the truth of the matter, that they can only consider the law enforcement have for context, as to provide context for why Mr. Crozier is responding. Other than that, any other hearsay concerns?
No other concerns.
Any other concerns?
No.
You had 2 reasons, you said.
Yeah, I gave them the hearsay of the other people.
Okay.
Subject to cross-examination
All right.
on video.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
How would you propose we do this, Mr. Bloodworth? Play the video with the scrolling transcript for the jury nowish?
Yes, Your Honor. Maybe in 5 minutes-ish.
Sure.
They drank a lot of coffee.
No, you and I both. Let me make a ruling here and see if either side needs clarification.
Yes.
Mr. Bloodworth, as I understand it, the state seeks to admit and publish to the jury a 13-ish minute audio-visual recording of Mr. Crozier's interview with law enforcement in May of 2023. The recording is accompanied by the transcript that plays below the video in real time. Is that correct?
That is correct, Your Honor. And it is labeled 8-64, D as in dog.
Okay.
864.
Having had the opportunity to listen to Mr. Crozier's sworn testimony in open court, and given that defendant had the opportunity to cross-examine Mr. Crozier when he was on the stand, has had the video, and that there's no evidence before the court currently that Mr. Crozier is unavailable to be re-subpoenaed and brought back into the courtroom by defense if they determine it's necessary to do so. The court determines that Mr. Crozier's half of that interview with law enforcement from May 2023 is admissible as categorically not hearsay under Rule 801D1A because he testified under oath that he couldn't remember the statements he gave during that interview. And therefore, the statements that he makes in the interview qualify as statements regarding which he has forgotten, quote unquote. The court will instruct the jury that they cannot consider any portion of the law enforcement side of that interview for the truth of the matter which resolves any hearsay issue with regard to the law enforcement half of the interview. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. It will be. 8-64D, as in Delta, is admitted on that basis. Let's take a 10-minute break. This clock in here shows 20 of 11. We'll come back at 10 of 11. Thank you.
Before we
Yes.
maybe get just a lineup, just so while we're on the break, we can take advantage of that. Be prepared for
Who's coming in?
Yeah, it hasn't changed from what I emailed you on Saturday, so I think.
Okay, perfect.
Yeah.
All right, folks, 10-minute break. Thank you. Court's in recess.
All right, sorry. I'm trying to eat my lunch so I can stay on track for today. All right. So, the prosecution is going to enter into evidence the interview with Robert Crozier while he was in custody. So, we get to hear from the police for the first time in an interview and how they are questioning him to get to what they need, right? And so let's see what kind of tactics the police are using to elicit information from Robert Crozier. And you saw Robert Crozier on the stand on Friday, and now here he is in jail. And remember, he said that he was still sort of like intoxicated from pills. So let's see. This will give you a balance test of whether or not you believe Robert Crozier on the stand Friday versus Robert Crozier in May of 2023. So let's we have lots of Zoom room, which is good.
Ruled on.
No, nothing further.
Okay. States 8-64D is admitted. We'll get that queued up now.
Okay, let's see how that goes.
Please proceed.
Robert, how are you? Good. I imagine you are. We'll get to why we're here in just a minute, real quick. Let me just get a little basic information from you, okay? How about an address for you?
16 East, 357.
What's the?
Your Honor, I'm so sorry, but you were going to give an instruction?
That is true. I appreciate that. Thank you for the reminder. Ladies and gentlemen, Mr. Crozier's side of this interview, this conversation, you may consider that for the truth, give it as much weight or as any as you determine it deserves. There are other speakers during this conversation. So the other side of the conversation, there may be 2 or 3 other people on the other side of the conversation. You cannot consider any of what they say for the truth. The only thing you can consider them for is to explain why Mr. Crozier is responding or to provide context for his responses. But the non-Robert Crozier side of this conversation is hearsay that cannot be considered for the truth. Anything further, Ms. Lewis?
No, Your Honor.
Okay. Please proceed.
So then we've lost the audio.
That's all right. I'll fix it. Scott, please give it a try.
And the phone number for you.
Okay.
Yeah. We'll get to it.
I'm about to say, I've been so much time.
I know you have, but you had involvement with people in Summit County. That's what we're talking about. Phone number for you, Robert.
385. I can even tell you, I'm sort of feed right now.
Okay.
I like my phone.
Okay. Tell me your phone number then.
Yeah.
Okay. So we'll get to why we're here to talk to you in just a minute. But before we do that, I'm going to advise you of your rights because you're obviously in custody here in jail, okay? So you have the right to remain silent. Anything you say could be used against you in court. You have the right to talk to an attorney with you during questioning if you wish. If you can't afford to hire an attorney, one will be appointed for you before questioning. If you decide to answer questions now that I have no lawyer here, stop questioning anytime until you spoke to a lawyer. You understand the rights I explained to you? Sure. Having the rest of my you want to talk to us today?
I mean, talking.
Okay. So we're here to talk to you about a transaction that you made little over a year ago with a female named Carmen Lauber that Nicole was you in touch with. You met her at a Maverick and Draper on 2 separate occasions in February of last year, so a little over a year ago.
Okay. It's not
Ring a bell at all?
She's in the
Okay. Well, let me give you a little more information. And so we talked to Carmen, we talked to Nicole. We talked to Nicole yesterday, got her phone and downloaded everything we need off of her phone. You sold Carmen blues on 2 separate occasions there at the Draper Maverick. As a result, somebody died from that transaction. So we're not interested in jamming you up or anything like that. We're simply here for information. But we know that you sold those, and we can prove that through cell phone records and that kind of stuff. But right now, your information for us is more valuable than you being charged federally with selling fentanyl. Now you're handling on some drug stuff. Do you know anything about the federal rules with fentanyl and 30s? And
I don't know anything. I know I've got a distribution of about 30 of them in December.
the M30s?
Yeah.
Okay. So tell us what you know. Like I said, right now your information is more valuable, but at this point we can prove. We know that you met with Carmen that Draper Maverick on 2 separate occasions. You sold her fentanyl. That fentanyl was then used in a death case, basically. So we tracked it back to this point, but we're not interested in jamming you up. We're here to try and corroborate information. Validate.
I know
what Carmen and Nicole have both already told us. So you're in the position right now of either telling us what you know about it and basically not hurting anybody because Carmen and Nicole have both already talked to us here and you're verifying information we have. Or if you don't want to talk to us, that's fine. We'll pursue it federally because we know that you sold them the fentanyl that resulted in the death. So that's kind of where we're at. And I'm not trying to bullshit you. I'm just kind of laying it out exactly how it is right now.
So I know who Nicole is.
Okay.
About a year ago.
February 5th and 25th is when Carmen messaged Nicole. Nicole gave her your information.
Okay.
Then you guys set up 2 transactions at the Maverick and Draper.
Of last
Yes. It's not this previous February, a year before that. It's been a bit.
year. And yeah, I'm so quite good. So very good. I'm not trying to be a different. I don't know. So sorry, remember that much time passed. And do you have a number that she bought for me? Was it a quantity?
She said between 20 and 30 pills both times.
Okay. Then probably. Yeah.
Do you remember going to that Maverick and Draper? Were you living down there at the time, or
She lives. I want to say she lives pretty far away.
she lives in Heber?
Yeah, so like that was just what we were meeting.
Where were you coming from? Where were you living at the time?
I've been living a little bit everywhere.
Okay.
Maybe the last couple of years.
So it's kind of ringing back. You're kind of getting a little bit more. Well, tell me what you can remember about them.
I remember Nicole calling me and saying, "Hey, can you be my friend?" And I was like, "Yeah." So and then she was like, "Oh, she wants a lot." And I was like, "All right."
Is 30 a lot for you, or is that a
No,
lot for Nicole?
I think it was a lot for Nicole, it wasn't a lot for me, but I was like, all right, I didn't know anybody died. You know what I mean?
Yeah, and we didn't expect that you knew that. And like I said, that's why at this point, your information, we're not interested in jamming you up or the distribution of it or anything like that. We're doing our investigation. You're kind of just on the edges of it a little bit as kind of an involved player, as being a hook basically for it. We're not interested in jamming you up or anything like that, but we are interested in the information you have to provide to us that validates what people have already told us.
Okay, as far as I know, yeah, I met her just 2 times. I think I talked to her a couple more times after, but just to see, you know what I mean? Hey, you know, because somebody's spending, you know what I mean? You know, $500-600.
Is that what 30 would run about $500-600?
Yeah,
So,
something like that.
okay. And did you hit her up afterwards to see if she wanted more, or did she hit you up afterwards?
I think I asked her one other time, and then she just didn't.
She's like, hey, you looking for any more or something?
Yeah, something like that. She just didn't respond to me. You know what I mean?
Do you remember how you contacted her? Was it through text messaging, Messenger?
But I want to say it's text messages, but I haven't had that. I haven't had it go on for the longest time.
What phone would it have been on?
My phone. Fuck. Maybe a 333-615-6 number.
You still have that phone? Okay. The phone you have now is a newer one then?
Yeah.
Okay. Have you contacted that Carmen at all? That phone or anything? Do you know where that old phone would have been that would have those text messages on it?
No, I lost that phone. A lot of it.
Okay. What did you think the phone number was you said?
385-333-615.
Okay. So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted, you know what I mean?
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxys, or what did she ask for?
No. I think she might have asked me for blue. I can't remember.
But you sold her M30s, right?
Yeah, I told her what she knew what she was buying.
Okay, so it wasn't like she's asking for oxys or something like that. She got the M30s.
Right, no.
Okay. So
No.
she knew that there was fentanyl in those pills. Okay. Do you remember where you got those pills from?
I don't.
Okay. What else can you tell us about that? That's all we're here to talk to you about was that transaction, those 2 transactions, I guess, a little over a year ago. We don't care about anything else, but What else can you remember about those?
She was with the older guy.
Do you remember what kind of car they showed up in?
No. Well, I think one time it was like a truck. Like a white truck or something.
Okay. When you say she was with an older guy, do you remember about ballpark how old he would have been?
I don't know, 50s, probably 60s.
You thought maybe one time in a truck, but you couldn't remember the other one?
No, they were in a car the other time. I don't remember what car.
Okay.
Yeah, the first time she was in the truck, for sure.
When you guys were to show up with the Maverick, where would you go? Would you go right back to Maverick or just right there at
Right
the
in
office?
Yeah.
Just a quick hand to hand.
Yes, there you go.
And you said about $600 or so is what you charge for those. Okay. Do you remember? So I think she would have ordered more the second time. Do you remember the quantity and
I
attitude?
don't remember the exact.
But you remember being there twice.
Yeah.
Okay.
I really remember meeting her twice because she told me that there twice. I would have said it once.
But do you remember now they're kind of
Yeah.
jogging your memory?
Yeah.
Okay. Do you think of anything else about those meetings with her or anything?
No, that's the only 2 times I talked to her.
Okay. How do you know Nicole?
This dude named Cam. I was staying with him, Roy, for a while. And she stayed there for a while, and then she took off, and then Cam's a fucking widow, and we all go take another one by her. So,
Okay. So Nicole just hit you up and said, hey, would you want to meet with my friend?
yeah,
You're like, yeah, that's cool. We were in the apartment. Did she call you or text you? Do you remember?
I believe she called me.
All the time or just that one time? Or
I think she would like say, she would text me like, hey, what's up? And then one of us called the other one.
you'd be like, hey, I'm Nicole's friend or whatever?
Yeah.
Okay. All right. How long was your, like, hey, I'm Nicole's friend or whatever?
Yeah.
Okay. All right. How long was your game there?
I think she would like say, she would text me like, hey, what's up? And then one of us called the other one.
Would you press pause? We'll fix that. My apologies. Go ahead, Scott.
Out there, or drug court or some shit, wherever she was living. She was on, she was either on AP&P or on drug court or something. I don't remember, and she had to hurry. It was always in a hurry. Like she was like, okay, well I'm leaving here now, so I can meet you like halfway. Can you meet me halfway? Oh yeah, I can do that.
And halfway was that Maverick there?
Yeah.
Draper?
Yeah.
Okay. You said one time she came with an older guy. Do you remember if that was the first time or the second
I
time?
believe it was the second time.
First time, do you remember if she showed up with anybody?
I don't know.
Okay. Okay, I think those are all the questions we had for you. If we have any more follow-up questions, you want to talk to us again as we kind of progress with this a little bit further?
Yeah.
Okay. I appreciate you talking to us, Robert. Like I said, we're not here to jam you up over anything. We're just here to try and get some information and see what you
You're not
got.
gonna fucking one day wake up with some fucking manslaughter charges.
No. We're not going to pursue that. Like I said, if you didn't want to help us out or anything, we kind of have this view right now that the people we're interviewing, we've got enough information. We're just trying to verify it. You're kind of either helping us out or you're not. And if you're not, you might, honestly. But all you've done right now, so we've already talked, Carmen's already talked, and Nicole's already talked. So you're not telling us anything we didn't know. You're not protecting anybody by not talking to us. All you'd be doing is basically rolling the dice with your future if you didn't want to talk to us, in a sense, because when the deaths are involved, the prosecutors do get a little spun up over it. And with fentanyl in the federal system, if you don't know this, if you get caught dealing fentanyl that results in a death, you could potentially face federal charges. It doesn't matter if you intended to cause the death or anything else like that. They're cracking down on it. So I don't know how long you're in for with. I know you're in on possession with intent stuff, but if you are still dealing, don't be dealing with that shit anymore because the feds are coming down hard on it, and it's only a matter of time, especially with how nasty that shit is.
And both of them bitches gave you my name, huh?
Listen, I'm not telling you how to crime, but stop dealing that shit. Oh boy. Oh, let me get out of the way because you can see the closed captioning.
Well, we already verified it through phone records. We already knew that they got it. It wasn't like they told us anything we didn't know either.
Yeah.
We've been able to find everything we need through digital evidence and all the contacts, all the messages on Facebook, all that stuff.
Yeah, we knew all of that before we made contact with anybody.
Yeah.
So it wasn't like they were diming you out or anything.
Yeah,
like
but I don't think me and Carmen even were friends on Facebook.
We actually were the ones that brought up your name to Nicole because we already knew that Nicole had put you in touch with Carmen, and we already knew all of that information.
Oh, okay.
So we're just trying to verify stories is all we're trying to do at this point.
Okay.
So Do you have any questions for us or anything like
No.
that?
Other than this isn't gonna backdoor me here?
No.
No. All right.
We're not here to jam you up or anything like that. We don't give a shit about what's going on down here or anything like that.
Okay. I was just going to ask you, do any of your people ever tell you what they're going to use it for themselves, if they're going to try to sell it to anybody else, what their intents are?
Everybody that I deal with does it themselves. You know what I mean? Like I do it myself, they do it themselves. You know what I mean?
Okay.
So it's
Carmen never mentioned anything about hooking it up for somebody else or anything like that.
no, like I said, like she was just like I met her twice. You know what I mean?
Yeah, and I figured it was a long shot twice. You met her a year ago. I knew it was going to be
Yeah.
a bit of a stretch for you to remember. But
Okay.
anything else you can think of or anything else you remember?
No.
Okay. As you think about it, if you do think of something, let one of the COs know or one of the investigators here at the jail know.
Okay.
They'll reach back out to us if you think of anything else you want to talk to us about or anything like that. Okay. Any other questions or anything like that for us?
You said
Okay.
Thanks.
Yeah, go ahead. All right. We'll go grab the CO and let them know you're ready. Okay.
Bring on the digital evidence. We want to see. We want to see your text messages. We want to see who, the what, the where, the when, how, and the why. So apparently they already talked to Carmen. They talked to Nicole. They verified their stories. He said he met her twice. That's what he said on the stand. He said he wasn't sure who she was, and then they brought him his phone, I think. So I think that might be a misstatement. But remember, this interview was a year after everything, and then now we're like 3 years after that. So it is what it is. All right, let's see who they're going to bring on next.
Mr. Bloodworth, the state's next witness, please.
Your Honor, the state calls Molly Crosswhite.
Molly Crosswhite. So we are at 23. I don't know. I don't know if the video interview is an interview. Do we count that as 23? Oh, I'm back on regular speed because they were going super fast. Ah. Okay, stop that.
Please raise your right hand. Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Please have a seat.
Please proceed.
Thank you, Your Honor. Good morning, ma'am. What, ma'am, is your name?
My name's Molly Crosswhite.
And is the last name spelled Crosswhite?
Yes.
Do you know who Kouri Richins is?
Not personally, but through this trial, yes.
Okay. Did you purchase a home from Kouri Richins?
I did.
When did you purchase that home?
It was January 26, 2022 is when we closed on that property.
Scott, can I get 8-12, please? Your Honor, permission to publish. This has been admitted already.
It's up.
No objection.
Ms. Crosswhite, do you recognize that house?
I do.
Is that the home that you purchased from Kouri Richins?
Yes.
Did you ever move into that home?
No,
Did you rent that home?
I did.
When did your renters occupy that home?
They moved into the property March 30th of that year. Their lease began March 1st, but they did not move here until the 30th.
You said you closed on that home, I'm sorry, the 26th or 27th?
I think it was January 26th.
January 26th, 2020.
Did they find fentanyl in the house? Sorry, I don't know. I'm making it up. Just want to know.
22.
Yes.
And was that home occupied between the date of the closing and the end of March when your renters moved in?
It was not.
Were the locks on that home the same as they were on January 26th when you closed to the time your renters moved in?
They were the same.
And did Kouri Richins rehab that home for you?
Prior to us purchasing it, it's our understanding she had done a renovation.
And did she have the keys to that home throughout that renovation process?
I would assume so.
Am I right then, as far as you know, that home was unoccupied between January the 26th, 2022 and the end of March 2022?
That's correct.
Thank you, ma'am. That's all the questions I have.
Ms. Lewis.
Good morning.
Good morning.
So, oh, excuse me, can I grab some water? So before you closed on the home, you entered into a real estate purchase agreement,
That's right.
right? And can you pull up Defense Exhibit 1024, Katie? Thanks, Alex. Ms. Crossway, do you recognize that as the real estate purchase contract that you entered into?
Yes.
And do you know the date that you entered into that?
Looks like it was January 14th, 2022.
Your Honor, we'd move to admit Defense Exhibit 1024.
No objection.
Defense 1024 is admitted. Would you like to publish?
Sure.
Okay.
And then Ms. Crosswhite, you closed on the home January 26th, was your testimony.
Yes.
Between January 14th and January 26th, did you do a walkthrough of the home?
Yes.
And what was in the home at the time that you did the walkthrough?
The home had been staged when they were marketing it for sale. So at that time, there was furniture in it. I think by the time we did our final walkthrough, which was a couple of days before we closed, all of the furniture had been removed from the
Right.
property.
Was there anything else in the home once the furniture was removed, such as boxes?
Not that I recall. I don't remember exactly what was still there, but I do know that we had wanted the home to be fully vacated and all of the debris, and there was some garbage and things on the premises, like old cars even, that we had asked to have removed.
So do you recall if there were any boxes or cups or any items left in the closet of the home?
I don't remember.
Had there been, would you have asked that that be removed when you did the walkthrough a couple of days before closing?
I think that if it was something significant that we would really notice as a bunch of garbage or something that was going to be troublesome for us to remove from the property, we would have asked for it to be removed. Like a small item like a cup, I can't say would have stood out.
All right, that's fair. Now, you said the renters, their lease began March 1st. They didn't move in until the end of March. But was there work being done on the home during the time you closed and the time the renters moved in?
There was.
And particularly, was there work being done throughout February of 2022?
Yes, I think I provided a list of dates that was on record with our contractor. I think there was maybe 7 different days in February when there were contractors working on the property.
Okay. Would some of those dates have been February 10th, 11th,
Yes, that sounds familiar.
12th, 13th, and 14th? Does that sound familiar?
Yes.
All right. And you think there were additional dates other than those 5?
I think there was 2 more dates the following week, maybe that the 19th and 20th, if that's, I'd have to look back at the records, but according to my contractor's records, there was 2 more dates in addition to those 5 that you named.
Okay. And when they were working on the house, do you know if they were there all day, most of the day?
I don't know how long they were there. We were having things like insulation added into the attic and mortar added to the pot rock because there was animals coming into the home and things like that. We need to get it ready for the tenants.
Okay. When you closed on the home, did you take possession of the keys?
I think that the key that was provided for us to access the home when we toured the property and made our offer remained at the property. I can't remember if it was hidden underneath, like somewhere at the front door. And we left that same key there for our contractors to use while they were working on the property.
All right. Did they keep the home locked?
I don't know.
Did you ask that they kept the home locked?
I would expect for them to. I mean, that's the point of a key.
Right. And the key wasn't in a visible spot. True.
No. I remember us having it hidden somewhere near the front door, maybe under a pot or under where anybody would think to hide a key. Probably not a great place to hide a key.
And it was your expectation the home would be locked throughout that time?
Yes.
Is that fair? All right. After you closed on the home, did you have any further conversations with Ms. Richins?
No, I never had any conversations with her directly. She was represented by another real estate agent.
Did you have conversations after you closed on the home with that agent?
I doubt it. I can't remember, but I would be surprised if I did.
Would you have told them the work that was going on in the home and who was in and out of the home? Would they have been aware of that?
I think that prior to us closing on the property, we definitely communicated our plans. It was part of our negotiations because we discovered quite a bit of work needed to be done in addition to the renovation that Ms. Richins had done. So I definitely had communicated, hey, we're not going to be able to rent this out the way that it is. We need, I think it was a $10,000 credit so that we were able to, complete the renovations in a way to make the home habitable.
Okay. And is there any reason they would have known not the purchasers, I'm sorry, the Ms. Richins or her agent you were talking to when, in fact, renters were moving into the home?
I don't know if we shared that or not. I know that we definitely communicated we could not rent it out right away.
Okay.
And we had to take care of quite a bit before we felt comfortable having people move in.
All right. Could I have one moment? Do you recall Ms. Crossway being interviewed by Mr. Bertram, in this case, the defense investigator?
Yes.
And do you recall telling him that when you took possession of the house, there was nothing in the house at that time?
Yes.
All right. And do you recall telling him at that time that you actually turned the key over to the contractors?
I don't remember. I never met the contractors on site, so I'm sure I did communicate to them where the key could be found on the property.
All right. Nothing further.
No, Your Honor.
Makes that 10. Is this witness released, counsel?
Yes, Your Honor.
All right.
Mr. Blower. Oh, sure. I shouldn't make assumptions. I apologize.
Okay, so just FYI, why was she a witness? That is the home that the alleged drug transaction had taken place. Remember, Carmen said she left there was a money in the shoebox, and then that's where they got the shoebox with the mugs, and that drugs might have been left there or in the fire pit or whatever. Is it important? I don't know.
Allison Wright, Your Honor.
Let's do it.
Prosecution thinks it's important.
It's on the first page. It's 840.
Okay, Allison Wright.
Good morning. Good morning. If you could please state your name and spell your last name. Allison Wright, Wright. Ma'am, where do you work? C&E Stonemasonry. There. Since established in 2010.
Did you know Eric Richins?
Yes.
How did you know him?
I first met him in junior high. He was a friend of my sister's. They were both in high school. He spent time at our house, and eventually we ended up in high school at the same time.
And is your husband was his business partner? Is that
Yes.
correct? Did you know Kouri Richins?
Yes.
How did you know Kouri Richins?
When I met her when she was dating Eric.
I want to talk with you about a couple of handwriting items before I ask you a few other questions. That's State's Exhibit 8-49 for the record. Sorry, I've got too many things on my podium here. All right. So I'm going to hand you this booklet.
Okay.
Okay, if you could turn to tab 4 for me. Do you recognize those items in tab 4?
Yes.
And if it's multiple pages, you can look through all the pages. Is it just the one page?
There's multiple pages.
Okay, and the first page is the one that you recognize, is that right?
Correct.
And go ahead and turn to tab 12 for me.
Okay.
And do you recognize those items?
Yes.
What are, in tab 4 and in tab 12, what are those items?
They are returned checks from C&E Stonemasonry's banking account.
And are those checks that you gathered and gave to Katie Richins Benson?
Correct.
And you gathered those from C&E's accounting books and things like that, their bank records?
Correct. The check on tab 4 was collected on an online banking, and the other ones were printed checks from our files.
What do you do for C&E?
Admin and bookkeeping.
Okay. So I want to switch gears. I want to turn your attention to February of 2019. Do you recall that time frame?
Yes.
Was there a time in February of 2019 that you took a vacation with Eric Richins and Kouri Richins and your families?
Yes. No, just the adults.
Just the adults. Okay, no kids were there. And do you remember a conversation during that trip with Kouri Richins that stood out to you?
Yes.
Go ahead and describe for the jury what you remember about that conversation.
on our vacation, Kouri and I ended up alone for a moment and just talking about our families, life, kids.
Your Honor, objection can be approached.
Yes.
Uh-oh. What is she gonna say?
Now that we're outside,
Oh,
Please have a seat. We're still on the record.
okay. Jury's out. They're gonna voir dire her to see what she's going to say before we can get into.
Sure, Nick. If you would just
Outside
ask
of-
the next several questions, we'll see where this goes.
Okay.
certainly. And so now that we're outside the presence of the jury, we're just going to get a preview of how you would answer the question that I just asked you. So describing what you remember from that conversation with Kouri Richins from the vacation.
While we were sitting there, we were discussing life, and Kouri then explained how things weren't super great in her marriage, how she felt trapped. She explained to me that there was a prenuptial agreement that was put in place, and I had never heard of that. She continued to say how I think the trap was mostly due to financial, is Eric would, because of the terms of the financial agreement, Eric would end up benefiting financially and continue to live as they currently were, where she would be in a different circumstance. She explained how she feared that the kids would be drawn to Eric's life and felt like she was unhappy in there, but feared what it would look like if she ended the marriage.
And is it okay if I ask a follow-up question?
Of course.
Did that conversation kind of give you context or inform you about Kouri, kind of what she was doing with her business at that time?
Yeah, things started to make sense. Like I was impressed that she went and got a master's degree. Kouri's motivated, hardworking, and I always admired that. And she was very motivated, it felt like, to become financially independent.
Your Honor, this conversation, can we get a foundation of exactly when in 2019 this conversation took place? Sometime in that year?
Mid-February.
Okay.
I think the trip started on the 17th. And I'm not sure what day.
Do you want to have this discussion with the witness
I
present?
do, outside that, if she could step down and step out.
Do you want any more for recollection before we have the conversation?
No.
Okay. Do you mind just waiting out in the lobby for us for a
Yes.
minute? Thank you.
Oh boy. Let's hear him argue whether or not this is coming in. Oh, Kouri, February 19th,
Your Honor, may it please the
2019.
court. According to Mrs. Wright, this conversation took place in February of 2019. 3 years prior, more than 3 years prior to Mr. Richins' death. In the interim, in between 2019 and 2022, the Richins attended marriage counseling and worked on their marriage, and a bunch of water under the bridge. To allow a conversation on a vacation in a situation where two women are just chatting about the condition of their marriage, 3 years, there's certainly no allegation here that Kouri Richins was planning to murder her husband 3 years in advance. Outrageously prejudicial due to the temporal distance in the statement that is being made. No relevance because it's 3 years prior.
Why isn't it relevant to show that Ms. Richins was aware of the outcome financially that would flow to her from a divorce based upon the prenuptial agreement?
She's aware of that when she signs the prenuptial agreement. They've entered the agreement that she signed.
This is, well, I mean, I think you've answered my question. It is relevant to show she's aware of it.
No, sir. The conversation in 2019 certainly isn't relevant. They have introduced a prenuptial agreement that she signed. It's clear that she knew.
I apologize for interrupting you. It's not clear because it doesn't, I have no evidence that she read it. I don't have any evidence that she understood it. Here, I have a witness saying she understood it, was aware of it, was fearful of it, was taking steps to mitigate.
Okay. If that's going to come in over my objection, certainly respect your ruling. We've made our record, but I would ask that all the rest of that conversation be stricken as too far away, about being trapped in her marriage, about being unhappy. Everything about that is utterly irrelevant and outrageously prejudicial. And we would ask that it be stricken and only be allowed to say that she discussed her prenuptial agreement, and that's it. And we also would like a continuing objection to any questions of this witness about any conversation in 2019. And we respect your ruling on that.
Okay. So defendants Objection to this series of questions of Ms. Wright is overruled. The testimony that was put on the record through the voir dire requested by defendant is relevant because it shows defendant's genuine subjective awareness of what she believed were the financial consequences that would flow to her if she and her husband divorced. It provides additional probative value because it shows that she was concerned about having less money than her husband if they divorced by virtue of the prenuptial agreement. She was taking steps to mitigate that potential financial effects. She was concerned about how her children might associate more with her husband by virtue of the lifestyle that he would be able to maintain in a post-divorce financial environment. That is all probative to the issues in this case, and it is not substantially outweighed by the danger of unfair prejudice.
Your Honor, can I also get a ruling just to avoid having to take another break when the jury comes back? Obviously, I have a right to go into her credibility and bias at this point, no matter what's being asked on direct, correct?
That's a very broad statement. You can certainly go into potential sources of bias.
Thank you. That's all I need.
Okay. Okay. Folks, let's take a 10-minute break. We'll come back at 10 of 12. Thank you.
It's coming in. Oh boy. Oh boy. Oh boy. So yeah. It's coming in. She knew she had a prenup. She knew that if they got divorced, her kids might prefer him over her because he has more means than she does at the time. But that this person admired her because she was getting her master's degree and felt that she'd be financially stable. Let's see if there's any more questions that they're going to bring up. Oh boy. Who wants some tea? This is getting good. I mean, we're like, oh, this is going to be a boring trial. I mean, there's going to be some boring stuff, but this is good.
Ms. Shervanek?
Yes, Your Honor.
Okay.
Yeah.
They can come in when they're ready.
All right.
Ms. Shervanek, please proceed.
So, Ms. Wright, before we took our break, I had asked you about a conversation you had with Kouri Richins on a vacation you took. When did that vacation take place?
February of 2019.
And what was that conversation? Describe for the jury what happened during that conversation.
Kouri and I were finally in a position where our husbands were no longer with us. We were just discussing life. We both have kids, our marriages, and Kouri opened up and shared that things were difficult at home. And a word I remember is that she felt trapped. At this time, I learned that their marriage had a prenuptial agreement. And she explained that she felt like she was frustrated in the relationship, but also it would be difficult to leave. Eric would end up financially secure and her the opposite. She feared what would happen in divorce. She mentioned that maybe the kids would prefer him with the lifestyle that they had, four-wheelers and toys and opportunities, where she would have less. She feared how she would be represented by him in the community. I felt for her. It was a hard conversation. I knew that things had been hard since their youngest child was born, and I was tender towards her current circumstance.
Thank you. And did that conversation give you any context to what was happening in terms of Kouri's business at that time?
Yeah. Kouri is super ambitious. She went back to school and got a master's degree. I was impressed. I had young kids. I wasn't sure I could do that. She then went and got a real estate license and was trying to build that business. That conversation kept playing in my mind as I think this is a way to become financially independent and secure.
Thank you. Those are all my questions for you. The defense may have some. Thanks.
Thank you.
May it please the court. Good morning.
Good morning.
This conversation you're talking.
All right. So the cross is going to be a little bit hard to swallow because you can see that they're going to go after her, right? They already asked if they could. So buckle up. I hope she's a little bit nice because this woman is just telling what she heard, right?
About happened in Hawaii, didn't it?
No.
Where was it?
Costa Rica.
I'm sorry, Costa Rica. And the reason you all were talking about her marriage, there was a reason she was upset in her marriage at that time, wasn't there?
Not that I know.
Scene card.
What?
She was upset. But I understood from the conversation is things were frustrating at home.
And that's because she believed he was having an affair with a coworker. Is that right?
Ah!
Is that right?
Oh.
She and I never discussed her thinking about an affair.
Is that the context of the conversation you were having that day, that she believed he was having an affair with a coworker, and that's why she was upset with her marriage and talking about divorce?
I don't recall that.
Were you aware of it at that time, that there was an affair going on between Eric and a coworker?
I don't recall that conversation
Okay,
versus
Kouri.
when I found out.
When did you find out?
Or wait, I'm sorry, will you repeat that question?
When did you find out that Eric was having an affair with a woman that worked with him?
These are facts, not in evidence. Assumes facts, not in evidence.
Foundation. You got to lay foundation for this. I'm not sure this witness knows anything about it. Why don't you ask?
You just testified that when you found out, you weren't sure if it was during this conversation. So when did you
No.
find out?
That's not accurate. You have to ask it open-ended.
Okay. When did you find out? Was it any time near this conversation?
Will you repeat that question with more detail?
When did you find out that Eric was supposedly having an affair with another woman in context to this conversation? Before, after, during?
I'm having a difficult time understanding because help me understand affair. Because like I think there was a friendship with a lady, but I don't know exactly what was going on.
Understood. That's fair. So let me rephrase it. Did you become aware that Eric had intimate feelings towards a woman that he was working with?
Your Honor, assumes fact, not in evidence.
She's
Argument on the
asking
question.
whether this person ever became aware of it. Overruled. It's a yes or no question. Ms. Wright, can we start there?
Can you repeat the question?
Did you become aware that Eric, at around this time, 2019, had intimate feelings towards another woman that he worked with that was causing problems in their marriage?
I don't remember when I became aware of it.
Ballpark.
I'm sorry. I think I'd heard of it like twice, and I don't remember. I'm sorry, I don't remember.
When you were having this conversation with Kouri, did you know at that time?
I don't believe I did.
All right, these vacations, you had vacations with Eric and Kouri on more than one occasion, didn't you guys?
Yes.
And then at some point, those totally stopped, didn't they?
Yes.
And what happened that made you guys stop going on vacations together?
COVID was the next year.
Besides COVID.
Our family life was busy.
In fact, didn't Cody and Eric have a big falling out? Your husband is Cody Wright, correct?
My husband is Cody.
And how does Cody Wright know Eric?
We were friends in high school. They went on to work together, broke off and started a business together, and maintained their friendship.
So they were business partners.
Correct.
And they both owned C&E Stonemasonry together, right?
Correct.
And at some point, your families quit hanging out. Personally.
We continue to go to birthday parties and like that kind of an event. No longer vacations. I think we had a vacation planned in 2020 that got canceled due to COVID is the one that I recall.
In fact, didn't Eric and Cody have a falling out over Cody calling the police on Eric?
Cody didn't call the police on Eric.
Did Cody provide testimony against Eric with relation to an investigation against Eric for violating hunting laws?
Lack of foundation.
Well, this is a different question. Ask her if she's aware.
Are you aware that Cody provided information to law enforcement against Eric for a violation of hunting laws?
Yes.
Okay. And Eric and him, as I would say, fell out over that. I don't know another word. Had a disagreement about that.
Yes, temporarily.
And you guys never vacationed together again after that, did you?
No.
All right. Now, you said that you did the payroll and the bookkeeping at C&E. Is that right?
We have a payroll service company.
Oh, sorry, sure. Okay, but you do the bookkeeping.
Yes,
So you know how much money is coming into that company, right?
correct.
And you know how much money is going out, right?
Yes.
And you and your husband have joint, do you share your marital money, or does he keep his business money separate?
We share our marital money.
Pause for 1 second, Ms. Nestor. Go ahead, Ms. Sherman.
This is outside the scope, correct?
Sustain.
All right. Setting aside your personal financial affairs, you're very aware of C&E's financial affairs, correct? Because you do the bookkeeping.
Correct.
All right. And
Objection, Your Honor, this is still outside the scope.
no, it's not.
Yeah, please approach. I'm not sure where you're headed here.
Boy, oh boy, oh boy, oh boy, just a boy, that was a lot. Some sort of an affair, we don't know. Maybe an intimate thing. That's not proven just yet. She didn't quite get there. And that Cody told law enforcement on him for falling out
Your next
for
question, please, Ms.
hunting loss. Wowzer. So much.
Since Eric's death, you and your family have grown pretty close to the Richins family. Is that fair?
Objection, Your Honor.
Goes to
Outside the
bias.
scope.
Goes to bias.
Overruled. If you would please restate the question.
Since Eric's death, you and Cody have become very close to the Richins family. Is that fair?
I would say the relationship didn't change.
So you were very close to them before.
Yes.
And it's true that since Eric's death, your husband has even accompanied them to court hearings and sat beside them. Is that right?
Yes.
Have you?
Yes.
And I think everything else is going to be when we recall. Ma'am, we're going to recall you later. We would ask that you're not releasing your subpoena, and the judge will instruct you about that. That's all we have at this time, Your Honor.
Okay. Anything within the scope of cross, Ms. Sherman?
Oh, look at Katie.
Of course.
No, Your Honor.
Okay. Ms. Wright, you're free to go today. You're still subject to the subpoena that you were served with. You may be called back. Between now and then, please do not speak to anybody about your testimony, including your husband. Okay. And please don't watch any coverage of this case. Don't read, listen, watch anything about it. Do you agree to do those things?
Yes.
Very good. You're free to go. Thank you for your time. Good time for a lunch.
Okay. I found her to be a very credible witness. I mean, she seemed like she was super truthful. She has nothing to hide. And it doesn't seem like she's trying to be malicious and be like, I know some dirt on Kouri. They had a conversation. She seemed very honest about it. All right.
Lunch break, counsel? Or do we have another short witness you want to get on and off?
Your Honor, we can break. I understand there's some legal issues to address too, so.
Understood. Okay. Any objection to a lunch break, counsel? All right, please rise.
Hey, legal issues.
Your Honor, we're going to quickly next call Detective O'Driscoll just for a phone download. We'll have perhaps more time later.
Okay.
But then it's Mr. Coach-Demos, and I understand the defense has some objections related to Mr. Coach-Demos.
Mr. Ramos, tell me more.
Thank you, Judge. I figured we'd do this just outside, that way we can speed things along. We've been provided with some exhibits that appear to rely, correct me if I'm wrong, on some CDR data, call detail records from Verizon and T-Mobile, I believe, and AT&T. Those items, we were not provided notice of their use under 901.11, and so we would just make an objection under that.
Forgive me. They were provided some reasonable time after being received by the state.
Yeah, no, the information was provided to us. We've had that for a while. Just notice of their use under that business record exception.
Give me that citation one more time.
Yeah. It's Rule 902.11. I believe is what it would be comes into in through.
Oh, state, what'd you do?
And specifically, I'm referring to the written notice
Why isn't inclusion of these records on the state's exhibit list fair notice under 902.11?
Just based on the case law, Judge, I could give you a citation. I have two cases I think are fairly on point. 32P3D 976, State v. Webster.
What's the other one?
And then 322 P3D 624, State v. Pereira. We just bring this up, Judge, now. We could have a ruling after lunch is fine. And that would be our only objection.
Okay.
Thank you, Judge.
Mr. Bloodworth, I made an assumption there, if you could just confirm it for me. These call detail records were in fact included among the state's proposed exhibits on its exhibit list?
Yes, Your Honor.
Okay. Anything further on this, sir?
Yeah, right, Your Honor. Just to clarify that, they've been disclosed, and the disclosure included the certification from the whoever returned the subpoena.
Right. The declaration. I understand your point to be slightly different than the self-authenticating piece. Got it.
Correct.
Okay. Pause there for a minute. I'll take a look at those two cases, Mr. Ramos. We can pick this up at 12:40. After Ms. Crosswhite testified, and after we took that break, one of the jurors passed out the following note. I'll read it. I don't think this is an issue, but just letting you know. Quote, Judge, I have met witness Molly Crosswhite professionally. She has done one transaction for a home where I work. Any concerns, Mr. Bloodworth?
No, Your Honor.
Oh, so a juror knows Miss Crosswhite. I don't think it'll be an issue.
Either following lunch or at the end of the day, may we address the motion for mistrial that you made at sidebar following the mention of jail calls by Ms. Gibson?
Yes, sir, I'm prepared whenever you are. Just
All
let me know.
Let's do that after lunch as well.
Okay.
Thank you. We will be in recess until 12:40. Thank you.
All right, they are in recess. We are not. Da, 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 da. Da, 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 da. By the power of Zoom.
Ramos is going to testify.
Okay.
3-9. Mr. Ramos, may we talk about the defendant's objection regarding the call detail records that I understand Mr. Contradimos is going to testify regarding? Is that correct, Mr. Bloodworth? Mr. Burnett?
That's my understanding.
Contradimos is the gentleman that they'll come in through.
I'm not going to be seeking to admit the call detail records.
I'm confused.
I imagine they were used for some of their demonstrative exhibits.
He relied on call detail records to create some of our exhibits.
Got it.
But
Good enough.
I'm seeking to admit the visual representation of those call detail records that he helped create, he'll testify came from the call detail records, although the call detail records themselves, the state is not seeking to admit as an exhibit.
Got it. Okay. I've looked at the Webster case. It certainly talks about notice with respect to Rule 807, which has a notice provision, and case law talking about how that notice provision works. The Webster case doesn't mention 902 at all. I'm not sure I was following your argument, Mr. Ramos.
Why am I showing you this instead of just witness testimony, right? This is important. This is about lawyers being lawyers, what's coming in, what can't come in. And them thinking on their feet, hey, I don't want this to come in. I'm going to fight for it. So they have to have case law to back it up.
Judge, the 902, 803 rules and those identified in the residual exception in Webster, they reference the same language, which is the notice language. That's what we were focusing on. I think Your Honor has enough to make a ruling.
Okay.
I understand your position.
Got it.
Yeah.
All right. So under Rule 902, subsection 11, records that can be self-authenticating under that rule before the trial or hearing, the proponent, in this case the state, must give an adverse party reasonable written notice of the intent to offer the record and must make the record and certification that makes the record self-authenticating available for inspection so that the other party, in this case defendant, has a fair opportunity to challenge them. All of those things have occurred. The call detail records and the certifications under Rule 902 that are included with them from the mobile service providers have been made available to defendant for inspection. through the discovery process. And by virtue of the fact that those records have been part of, or at least the portions of those records that the state seeks to publish to the jury have been part of the state's exhibit list, the state has given the adverse party reasonable written notice of the intent to offer the record. The court finds that defendant has had a fair opportunity to challenge those records. Any objection to the admission of that call detail record information under 902.11 is respectfully overruled. Anything further, Mr. Ramos?
No, Judge. There will be through Mr. Kocher-Demas some testimony regarding the .pmg files of the gist. I would at that point probably ask why you removed this, assuming they're going to be asked to be introduced evidence. So I just let the court know now, and it's sure of that.
Which file type was that?
They're like GIFs. They're those GIFs that were presented during.
Oh, the pathways that link to those.
Correct.
Got it. Okay.
Can I ask just a general question, just to avoid, because I think it's going to come up. So it's my understanding that the extractions have now been put into evidence, correct?
Yeah, but not the physical documents,
But
but the extraction, but the testimony about who extracted or downloaded the phones. Yes.
And we put the phones in, but we have not put in the actual, we've not put in the report, the data that's been fed into the Celebrate software platform. Is that in?
The raw data is not readable.
I know. The raw data is in through the phone, but is the Celebrate data that has been extracted by Intel, was that put in?
Not yet.
Okay, so if that's not in, how do we have from Koster-Demas, how can he put in the demonstratives that are based on that? Because it's just basically it just makes it into a picture, but it's the data from what's not in yet.
So you have witnesses talking about the physical device containing electronically stored information was secured.
Correct.
You have testimony creating a chain of custody to the people that downloaded it through a two-step process.
Right.
The gray key,
Right.
forensically mirrors that phone. And then Cellbrite is how, among other people, I imagine Mr. Kocher-Demas would say, I was able to read and process and parse out, quote unquote, that information. Not everything on that phone is relevant, so not all of it goes in. We're going to see what parts the state believes are relevant through Mr. Kocher-Demas. He hasn't testified yet.
So he's going to be allowed to testify what's the information that's in something that hasn't been put in yet. Because without putting in the extraction,
There is no basis to admit the extraction. There is a lot of information on that phone that I imagine is not relevant under
Sure.
401 or 402.
Agreed.
So there's no basis to put in the entire extraction.
So
It's
this
not
is-
like an encyclopedia.
well, then this is getting to the core of what my concern is.
Yeah.
And I'm just thinking out loud to try to avoid wasting Koster-Demas's time. But let's say, hypothetically, we want to get some of the extraction information in at a later time.
Do you have an expert that has looked at those extractions with Cellbrite and can testify and lay foundation?
We do.
Okay.
No problem. But my question is whether our expert can do the same thing theirs is doing, which is relying on data they saw in Celebrate and parsing it out without the Celebrate extraction coming in. Because as long as we can do it too, I'm totally fine with this whole process. But what's worrying me is we're going to get to my side and they're going to say the extraction's not in, your expert can't testify. So I guess I just want to make sure we're all on the same page. The extraction doesn't have to come in as long as our expert has reviewed the extraction and they've laid a foundation for authenticity of the extraction, which, by the way, I don't think either side is challenging the authenticity of the extraction ultimately. But the same thing's going to apply when our side gets up and our guy says, this is the what.
Okay, so this is funny because she's like, Your Honor, can you tell me how to do my job? Can you tell me how this goes? And but she's very cautious and she has every reason to be because I'm not saying that the prosecution's playing trickery, but they are playing very things close to the vest. And just as you saw earlier with Katie Richins Benson, who they didn't talk about her report or the things, they didn't talk about the trust. They didn't go into the trust. They only like they glanced over it. And so she wanted to get into the trust. And they're like, we didn't bring it in through this witness. So you can't talk about it. And so she was just like lambasted, like, holy crap, I want to talk about it. I can't. So now she's trying to make a record to make sure that she can do what she wants to do and that she won't be blindsided.
What I pulled out of Celebrate, I'm going to use this in what we're going to present.
Are you talking to me about?
I'm talking to you.
I'm not sure what you're asking for.
I'm asking if we need to have a hearing now about whether the extraction has to be admitted for all this to come in, or if the extraction doesn't have to be admitted, there's no problems.
The only reason we've talked, as I understand it, about the extraction process at all is to lay foundation for the expert testimony of people like Mr. Katradimos.
Perfect. So you will not require for Kostradimos to testify about the data that he read from the extraction. You are not going to require the extraction to be admitted into evidence, because if that applies, then that applies to us too, and we're fine with that.
As long as your expert is an expert and doesn't have to say or do something else objectionable. I don't know who your expert is or what they're going to say, so I need to be a little bit circumspect here. But the fact that a copy of the extraction from Gray Key on a portable hard drive has not been admitted as an exhibit is not an impediment to this kind of expert testimony.
That is exactly what I needed to know, because if it is, we need to have a hearing on it. And if it's not, then there's no problem. But I just want to make super clear that we're all on the same page, that it doesn't have to come in for us to pull things out of it and admit it.
Yeah, I think we need to keep in mind the life cycle of these things. There's information gathering, there's chain of custody and information preservation, and then there's what's admissible and how it comes in.
Sure. The only reason it's just unique is because the phone itself, without the extraction, the hard data is not readable, as the witnesses have talked about.
Right.
I mean, like, if the juror was given what was extracted out of the phone, they couldn't do anything with it anyway.
You and I agree.
Okay, I just want to make sure that we don't do that wrong, so that the extraction, the hard drive extraction itself doesn't have to come in, and we can all pull pieces out of it that we want because the foundation's been laid.
Now, I want to be careful. You're saying the extraction. There are several.
There are.
I'm familiar with the ones for which foundation has been laid so far. I don't know whether you're talking about some other devices regarding which foundation has not yet been laid.
Eric Kouri's phone.
This is, again, I feel like you're talking to the state, not me.
Right.
No. I think we're all in agreement that the extraction doesn't have to come in. As long as the extraction doesn't have to come in and we can use pieces of it,
Miss Nestor, this is a question for you to talk to the state about, not the judge. The judge is not the babysitter.
totally fine.
Provided sufficient foundation
Sure,
for the
to show it's
extraction has been
admissible,
laid.
to show it's admissible under other grounds, 4.1, 4.3, hearsay.
Authenticity, yeah.
Well, authenticity is an issue, right?
If you're talking about a device that we haven't talked about yet, you're going to have to lay some foundation.
No, assume for purposes of this conversation, it's only devices that have been admitted. So
For the purposes of this conversation and putting aside other 702 related objections that the state may make when your expert witness is testifying, what's good for the goose is good for the gander with respect to the extractions.
Perfect. Perfect. That's all I needed. Thank you very much for taking the time. I do think that's really complicated and strange because of the way that the extraction is a different data set than the actual guts of the phone, which is unreadable. So that's why I just wanted to clarify that. So thank you very much.
Okay. I forgot how that began.
Oh, the juror issue. We got to talk about the juror issue.
We can switch to that. Anything else regarding Mr. Katradimos before he takes his stand? Ms. Sherbanek?
Nothing from the state.
Mr. Ramos? Okay. The juror note. Go ahead, Ms. Lewis.
Your Honor, we do have some concerns about the note that came out from the juror. First off, I believe that had we had this information during jury selection, this juror would have been weeded out in the process because they had a business transaction with the witness. So now we have someone on the jury who I believe, based on our parameters, wouldn't have even made it to the final pool. So that's concerning. The other concern is we don't know anything about the interaction with Ms. Cross-White, positive, negative. I did have to push back a little. That concerns me a little bit that, if he thinks very highly of her, that could be some bias that I did have to get up and push back. And our position would be out of an abundance of caution. We dismiss that particular juror.
Are you prepared to address this now, Mr. Bloodworth, or do you need some time to think about it?
Your Honor, we can address this now.
I want to be transparent. I'm not going to rule in this moment. I will need to just take a look at what legal standards, if any, there are regarding this. But if there's anything you want to put on the record now.
Can I just add, I'm sorry, Brad. It is our understanding that Ms. Cross-White went by a different name. So I'm not implying this juror intentionally withheld information. He may have known her by a different name.
Understood. Go ahead, Mr. Bloodworth.
Your Honor, I don't know that the jury note provides the court with sufficient information to make
Right.
a determination at this point. It seems to the state that a little bit of voir dire would probably benefit the court, but based on what the information the note contains, I don't see cause to strike or dismiss this juror.
All right. Ms. Lewis, my sense of this is I don't need to rule on this right now. I can give it some thought. There's no harm in leaving the juror right where they are for the time being.
Agreed.
Okay. I won't lose track of this. Let me think about it for a minute. It may be that I just need to ask this person a few questions and then we'll go from there. Okay. Motion for mistrial, Ms. Nestor?
Sure, just really briefly. As the court will recall, during the time that I had Ms. Chelsea Gibson on cross, I was trying to lay a foundation to later get in some of the home wave calls that had been downloaded. According to her reports that we were provided, she was the individual who downloaded all of them and stored them into evidence. And I believe that I had to at least lay a foundation of authenticity if I later wanted to admit those calls. So I was trying to do that. I was trying to do it very carefully. I warned her to please copy my language. I looked right at her. I used very specific language, and her response was, "You mean the jail calls?" I understand things like this happen in trial, but the case law that's relevant, I believe, it implicates Ms. Richins' Sixth Amendment right to a fair trial. It affects the presumption of innocence because if the jury is aware that she's been incarcerated, there's been case law that says that can impact your presumption of innocence. There is a pretty recent case in Utah, State versus Bernejo, Bernejo. The site is 476 P 3rd 148, which acknowledges that evidence of custody status can carry the risk of prejudice. I will absolutely concede all the case law gives you so much discretion in this area because every circumstance is different. Every situation is different. They really, really do rely on the trial court judge to make a call in the moment. Now we have this situation through no fault of mine where the jury now knows that at least for some period of time, my client was in jail and communicating with family. And she did use the phrase calls with an S to indicate there were multiple calls, although she didn't say how many or for how long. And I concede that. So we would, and also the case of State versus Atkin, Atkin, 135 P 3rd 894. Again, there's a quote, "It may be prejudicial in certain cases." Full disclosure, both of these cases, the court did not find sufficient prejudice to overturn the call the court made in the moment. I think actually Bernejo may have been they were challenging whether the lawyer was ineffective, I think, for failing to make a mistrial objection. If I'm not mistaken, I think that was Bernejo. So I'm not even sure the judge made a call on that case, but I do believe on Atkin they did. So based on the authority, the recognition that it can bring prejudice, based on the fact that this case did happen so long ago, so the jury would put two and two together and realize my client's been in jail the whole time, possibly. It's an inference that could be made. We did move for mistrial. I will state for the record, the court did provide a special instruction, limiting instruction, warning the jury not to consider that. That's one of those, difficulties because it does then again highlight that comment was made, but we were trying to do in the moment the least amount of damage going forward. I did agree to that instruction being made. I did not object to it because at that point I felt like something needed to be addressed. But that was the basis of the motion, and that's all the record we need to make.
Okay. Anything further, Mr. Lower? I think I have this firmly in hand.
Yes, Your Honor, the state rests on the record that we made at the sidebar.
Okay, very good. The issue before the court is a motion for mistrial made by defendant following Ms. Gibson's reference to jail calls, quote unquote, during her cross-examination. The court finds that that statement, while improper, was not intentionally elicited by either party. It was inadvertent. It was made in passing. It was a short, quick reference. It is relatively innocuous in light of both the volume of testimony that the jury will hear in this case over the course of 5 weeks. It is relatively innocuous in light of the fact that this is a homicide trial. And so it would not come as a surprise to jurors that the defendant in a homicide trial may have been in custody at some point in the case. And moreover, the court gave a curative instruction that specifically instructed the jury not to consider that comment, not to speculate about whether defendant was or is in custody at any time in this case. Based upon those findings, the court finds that a mistrial is not required. Defendant's motion is respectfully denied. Anything further on that, Mr. Bleber?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Ms. Shervinack, anything else before we invite the jury in?
No, Judge.
Ms. Lewis? Ms. Nestor? Okay. We're ready for the jury.
All right. So remember, I said that I was going to parse out the trial. We're at 1 hour and 14 minutes. So I'm going to go ahead and pause here, and I'm going to upload this here, and we'll move on to the next one. Lots of moving parts today. Lots of things behind the scenes. Jury in, jury out. Lots and lots and lots of housekeeping, other things going on. So we left off with Molly Crosswhite. We started the stream with the interview of Robert Crozier. We talked a little bit about that. He pretty much said the same thing that he said on the stand. That he said he believes he sold M30s. He didn't believe he sold fentanyl. It was about between $500 and $600. But remember, it was a year after the incident. He said he needed his phone to verify whether or not it was Carmen, but I seen the interview. He didn't ask for his phone. The police stated, although we cannot accept what the police stated, but they alluded that there was text messages, etc., to corroborate the story of Nicole, who was the go-between between Carmen and Robert Crozier. Next up, we have Molly Crosswhite. She purchased the little cottage house from Kouri, and she had possession of it apparently during this time frame where the money exchange and pill exchange was happening between Carmen and Kouri. Is that a big deal? I don't know. But they put it in nonetheless. Okay, Allison Wright. Oh boy, Allison Wright is the wife of the business partner, Cody Wright. They had gone on a vacation in 2019. It was just the adults. Apparently, Kouri had told her that she felt trapped. There was a prenup in place and her marriage wasn't great, that the kids would prefer Eric's lifestyle because he had all the toys, the four-wheelers, etc. Kouri was a savvy person. She was getting her master's degree. She got a real estate license, so she felt that perhaps maybe she would recoup financially if there was a divorce. And Cross was hot and heavy. She knows of some person that Eric might have been interested in, but doesn't know firsthand whether there was an affair or what that relationship was. There was an incident between Cody and Eric about a violation of some hunting laws, and Cody turned Eric in, but we don't know what transpired from that. Just we know that there was somewhat of a disagreement, and that Cody and Allison have been attending the court hearings with Kouri Richins' family. All right, so then there was some talk about whether evidence is going to come in or not come in via the next witness, talking about the Celebrite extraction. And then there was the mistrial argument about the jailhouse call statement that Ms. Gibson made. The judge made a curative instruction. It's innocuous as to many witnesses that are going to be coming in. And he said that, they are not to consider that statement, and that therefore the mistrial is denied. So we're going to go ahead and stop it here, upload this one, and then we'll get ready for hopefully the rest of the day. I think that they're ready to go. So thanks for watching. I hope that you're enjoying things, and make sure you like and subscribe, and obviously share with people in your lives, because it's fun. This is fun for me. I hope it's fun for you. Thanks. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.